Yeah, Miranda refers to Miranda v. Arizona, or Arizona v. Miranda. Anyway, Arizona case involving Mr. Miranda. And I think most people are familiar with the Miranda warning itself. You have the right to remain silent. Anything you say or do, actually. I guess that's one place where Georgia's a little bit different. We have more protection against self-incrimination than what's guaranteed under the Constitution. So not just what you say, but your acts. You can't be required to, in Georgia, under our Constitution, not only can you not be compelled to speak, you cannot be compelled to act. And that's why they can't force you to do field sobriety testing. You have to do that willingly. But yeah, anything you say can and will be used against you in a court of law, and you have the right to an attorney. There's a long, I guess if you're like a legal nerd, there's a very long history of issues with interrogation and confessions, and then like the standard tactics that were used by law enforcement, both pre and post Miranda, and how they tend to be coercive, especially towards people who are more limited intellectually. As I recall, Mr. Miranda was intellectually, if not disabled, certainly limited. And the main, and again, like I say, it's a very long, you could really go down a rabbit hole on Miranda and false confessions and coercion. But if I can give sort of an abridged version of what they were trying to address, there was a real issue with false confessions. Because being particularly like in an interrogation setting, where not only are you pulled off to the side of the road, like you're locked in a room, law enforcement won't let you go. They would deprive you of food, they would deprive you of sleep. In some cases, they'd beat you, Things were pretty wild, especially, decades ago. And not as long ago as people would think. As recently as the 50s or 60s, like they were, they would beat a confession out of you. And that was really what, not the beating, not the torture so much, but the coerced confessions is what they were trying to get at with Miranda, which is you're a lay person, you're not an expert, particularly if you're on the lower end of the intelligence scale. You're very susceptible to these techniques, and I guess I could tell you a little bit about that. As they on the law enforcement side of things, I don't know what you would call it. It's, they have these professional organizations and things that they belong to, the fraternal order of this and that. And, they would go away for training just like, a lot of professionals do. I have to go to annual legal training every year, to keep up on the newest areas of the law and techniques and things like that. Well, law enforcement does the same thing, but there were interrogation tactics, like schools of thought that were developed and, kind of fine-tuned. And the problem was that these interrogation techniques got so good that they would get confessions not just from people who were guilty, they would get people who weren't guilty to confess as well. And so, yeah, Miranda was seeking to at least level the playing field, like make sure that the person knew, like, hey, you don't have to talk. And you're entitled to have a lawyer present. And either one of those things, if you just invoked one of those, that would likely keep you from giving a false confession. If you don't speak at all, obviously you can't confess. And if you have a lawyer there present with you, they can, tell you not to say that, or kind of keep an eye on things that are going on, and kind of manage the questioning. The proffer really is what it is when you've got a lawyer there present with you. So yeah, they created this. It was a little bit controversial at the time, and I guess it's a little bit, in some circles, controversial now, insofar as, on its face, there's really no requirement on the Constitution that an officer advise you of your rights. On the whole, though, I guess kind of setting that issue aside, whether it's actual good constitutional law, it is binding precedent today, and I think on the whole it's been a positive. Again, just from the false confessions aspect. Now, what it actually means in practice, and I'm sure a lot of attorneys hear from a client, well, no, they never Mirandized me, so this case needs to go out the window. And it's like, well, did you confess? Well, no, but they didn't Mirandize me. I was like, well, it doesn't work that way. The failure to Mirandize you doesn't just invalidate the case. What failure to Mirandize would do, actually does, is if you give any evidence, meaning you speak, you give a confession, or you tell them where evidence is, and you haven't been Mirandized, that confession and that evidence cannot be used. If they have enough evidence without what you gave them to proceed, they can still prosecute you. It's merely, Miranda is merely used to exclude evidence obtained illegally. It does not invalidate a case. Yeah, so Miranda does not on its own just invalidate a case from failure to give you your Miranda warnings. What it'll do is it'll exclude evidence that is obtained through either confession or just through speech from a suspect who's not been properly advised. So if you tell them where the murder weapon is, and they didn't advise you of your Miranda rights, that may exclude both the fact that you know about it and the murder weapon itself, with some exceptions. One exception is if it was inevitable that they would have found it anyway. So if it was sitting in your car and they had enough evidence to search your car anyway, or if it was left somewhere where it would most certainly be found, then it would not necessarily be excluded. The other thing is, if it wasn't in response to questioning from law enforcement, if law enforcement shows up and you just spontaneously confess and they didn't ask you anything, Miranda's not going to cover that either. So really it needs to be, and it only applies post-arrest is the other thing. So law enforcement doesn't have to Mirandize you if they just walk up to you on the street and say, hey, do you know anything about this? You have to be in custody. It has to be, in response to some questioning from them. Yeah, while in custody, in response, not spontaneous, and then not leading them to something that was inevitable in the first place. So once you assert your Miranda rights, you can also waive them again later. This is one of the big cases that they teach everybody in law school because it's such a big deal. You can, so if you're given your Miranda warning, you say, okay, I want to remain silent and I want my lawyer. They say, okay, they put you in the back of the car and then they start driving you to the station. They're not saying anything to you. You have a change of heart. You start talking to them. once you've been advised, even though you've said no, you've asserted your rights, if you reinitiate conversation with law enforcement and then you start talking to them, you can waive your Miranda rights that way, even though you've said you want to exercise them. Your actions were different. They're actually even given a little bit of leeway to ask you some things. So, you know, if or not ask, but kind of talk to you some. They usually don't do it because it kind of muddies the waters and creates problems down the road. But if they, say you're driving in the same scenario, you've asserted your rights, and then you start driving, and then say the officers, they say there's two in the car, they start talking to each other where you can hear them, and then you interject and then start saying things. Or, if they start talking to you not about the case, and then you bring this up. They have allowed, as kind of a narrow exception,